Thank you.
Yes. Oh, Deputy Law, can you mute us?
You want us up there, Judge?
No, you can remain there. All right, we're on the record in 2022 CR 8529, State of Texas versus Melvin Jones. Can I have parties announced for the record for the state?
From reporter from Mr. Jones.
Oh, and are you Mr. Jones? All right, you can be seated. The court received, we received more than one question from the jurors. The last question that was received from the jurors was the following. We're at an impasse, 9-3, on the less than a gram charge. What happens if we can't all agree? State, are you asking the court to send an answer to the jurors, or has an agreement been reached between you and the defense? Defense, are you asking the court to send an answer back to the jurors, or have you and the state reached an agreement?
No answer, Judge, and we have reached.
All right, Mr. Jones, you understand that you're in the middle of a jury trial? Do you understand that? You understand that the court could send an answer back to the jurors. The jurors could possibly continue to deliberate. Do you understand that? Are you in agreement with your counsel that the court not send an answer back to the jury and that you've reached an agreement with the state? Right. All right, for the record, it's the court's understanding that the defense is in receipt of all discovery. Is that correct, defense? Court will find that the state is in compliance with discovery. And Mr. Jones, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented? Any objection? Mr. Jones, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea, then you will be allowed to withdraw your plea and proceed with a trial. Did you understand? And it's the court's understanding that the agreement is open to the court. Is that correct, stating the defense?
Yes. Yes, Your Honor.
Mr. Jones, do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea bargain agreement in this case? And just so the record is clear, we're currently in the middle of a jury trial. The jury is out deliberating, and you are asking that I allow you to enter this plea and that there be no jury trial. Is that correct? Counsel, has your client been able to provide you with any defenses?
Yeah.
Do you believe he has a rational as well as a factual understanding of the charge against him?
Yeah.
Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Jones, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it? According to the plea, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1, less than 1 gram. And you are to plead open to the court. Did you understand that to be the plea? And that you understand that to mean that the court could sentence you anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. And you understand that you have not filed an application for probation or deferred adjudication. Okay. Did you understand that to be the plea bargain agreement? Defense?
Yes.
State?
Yes.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions? Then to the lesser included offense of possession of a controlled substance, penalty group 1, less than 1 gram. How do you plead? Guilty, not guilty, or no contest? State, any evidence to support the plea?
State offers to exhibit.
No objection.
Mr. Jones, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Again, did you understand that we are currently in the middle of a jury trial and that you're asking that the court consider your plea bargain agreement with the state, and you are asking that there be no jury trial and that you entered a plea? Is that correct? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. We will come back on June 8th. And at that time, counsel, with regards to any of the matters with the other prosecutor, Mr. Lunan, the court can have an idea as to what date that will take place. And state, on this case, if you all can make sure that the court has access to any criminal history, and Mr. Porter, anything that you wish the court to consider with regards to punishment. All right, is there anything else from either side? All right, so we will bring you back on June 8th. All right, thank you. And if anyone wishes to come back and talk with the jurors with me, you can. I always